Tell me and I may forget. Teach me and I may remember. Involve me and I will learn. So it's an effort by BVV Sanghas, Basweshwar Commerce College, Bagalkot, Department of Management Studies, BBA, organizing intellectual property rights with coverage of IPR violation and plagiarism to involve all and to learn about IPR. A very good evening to all the respected dignitaries, seniors, colleague friends and dear participants. One song can change a moment, one idea can change the world, one step can start a journey. So to begin this journey, I request Professor Vidya Ivastred to extend a welcome for this informative session.
A very good evening to all. It's my great honor and privilege to welcome the Chief Patron, Dr. Veeranna C. Charantimat, MLA, Honorable Chairman, BVV Sangha, Bagalkot. I welcome you, sir. It's my pleasure to welcome the Patron, Shri Mahesh N. Athani, Honorable Secretary, BVV Sangha, Bagalkot. A warm welcome to you, sir. It's my honor to welcome the President of today's virtual seminar, Shri Guru Basava S. Sulibavi, Chairman, College Governing Council, BVV Sangha, Bagalkot. Welcome you, sir. I am very glad to welcome Srimati S.H. Shatta, Principal, Basweshwar Commerce College, Bagalkot. A warm welcome to you, ma'am. I am very glad, happy to welcome today's resource person, Miss Simona S. Wahid, Assistant Professor, LLM, Intellectual Property Right, KLE Societies Law College, Bangalore. I welcome you, ma'am. I take this opportunity to welcome Professor Nandaraki sir for this seminar. NAC Coordinator, Basweshwar Commerce College, Bagalkot. Welcome you, sir. I take this opportunity to welcome all the faculty members, all the participants and gatherers. I welcome you all for this wonderful seminar. A very warm welcome to all of you. Once again, thank you one and all. Over to you, madam.
Thank you, madam. I now request Professor Nandini Dodmani to put forward the introduction of our resource person, Ms. Simona Wahid, Assistant Professor, KLE Society Law College, Bangalore.
A warm good evening, everyone. Intellectual property is a key aspect of for economic development. Taking our evening further and to begin with the intellectual property rights program, I, on behalf of everyone who present virtual seminar, once again heartily welcome the chief guest and a dignitary of a priceless program today. I am especially thankful to Simona Wahida ma'am, as when we approached her with the IPR invitation and requested her to grace the evening as the chief guest, madam, without speaking next word at all and instantly agreed, she carried over the program. I am very much thankful to you, madam. It's my honor and a privilege to be introducing Professor Miss Simona S. Wahida madam. Madam has completed her BA LLB from a National Law University and a Judicial Academy, Assam in the year 2017. And Madam completed her LLM in Intellectual Property Rights from National Law University, Raipur in the year 2018. Madam, area of interest are intellectual property rights, commercial laws, and international law. Presently, Madam is a faculty in charge of Navobhav in the IPR cell of KLE Law College, Bangalore. We are honored by your presence on this occasion, Madam. Thank you, one and all. Sheetal, Madam, over to you, Madam.
Efforts and courage are meaningless without purpose and direction. So we are looking forward for the address by our principal, Professor Srimati S.H. Shettar, Madam. I request you to address today's session, Madam.
Yes. Good evening, Simona madam, and to all participants. Dear participants, today's webinar topic is very important, that is intellectual property rights. It plays a significant role on a trade of every nation. IPR is one of the source of security for intangible properties which are still open to the public and which can be quickly replicated by anyone. Dear students, IPR awareness is very important for fostering innovations, for protection of ideas of business and individual, and to focus more on research. IPR empowers you to profit from your creative assets. IPR can help businessmen to establish brand, identity, profit of unique assets, and also prevent others from using your creations. Dear participants, today's resource person, Simona Madam, will give you the knowledge of IPR, how you can protect your intellectual properties, your business against IP theft, and also she'll give you the knowledge of who owns intellectual property and how IP ownership determined and what type of intellectual property is being violated, and also madam will give you the awareness of the consequences of plagiarism tool today to have successful academic careers and to acquire and retain the information in order to write a paper in your own words. Dear participants, hope today's webinar will guide you to develop in coming days. We are very thankful to Simona Madam for sparing her valuable time as well as sharing her knowledge with our students. Thanking you one and all.
If your actions inspire others to dream more, learn more, do more, and become more, you are a leader. So, to lead this seminar forward, I request Ms. Simona Wahid to carry on the session. Over to you, madam.
Thank you, Shikal madam. Thank you, Principal madam and Nandini madam, for your kind words. My introduction was way more than I would expect anywhere, but thank you so much for having me. And I hope I can deliver to you what is expected from me. So I am given to understand that most participants will be on YouTube Live, and I will not be interacting with them, but I would still like people to respond speak their mind whenever they want. I have the YouTube Live channel open on my phone, so if you want to respond to something that I say, please do so. Please feel free to quickly respond. Now, I'm going to share. I'm trying to share my screen. I don't know if that'll be possible. Okay. Just let me know if you can see my screen.
Yes, madam. We can see your screen. And one more thing is we will update the queries which has been asked in the YouTube.
Okay.
So
perfect.
Okay.
Perfect. Is the PPT visible?
Yes, it is visible, madam. It is
okay.
visible.
Great. All right. So the topic that I'm supposed to speak about today is intellectual property rights violation and plagiarism. Now, to begin with, I will start off with a caveat. It's a huge topic, and there is, n number of things that I could go on telling you about intellectual property rights, its violation, and also plagiarism, which comes as an ancillary aspect of intellectual property rights, more specifically with respect to copyrights. Okay, so how I'm going to go about today's lecture is I will try to tell you what intellectual property rights are, and then we will go on to look at what are the different kinds of intellectual property, how they're violated, and what plagiarism constitutes. So, to begin with, when we talk about intellectual property rights, we are referring to property. So first thing that we need to understand about intellectual property rights is that we are referring to a certain type of property. Now, what is interesting here is the fact that when we think of property, we usually think of a house, a plot of land, or let's say maybe your books, your laptop, all of that is your property. But when we talk about intellectual property, this, like Madam Principal has already said, is a type of intangible property. Intangible in the sense you cannot perceive it with your five senses. Meaning these are rights that you have over something which you cannot touch, feel, see, hear. These are rights which are simply intangible. Essentially what this means is that how do you prove, see, if you want to say that I'm the owner of this house, how do you prove it? You either have the keys to the house or you're in the house, so you can say that this is my house. Okay, now with respect to intellectual property, how do you say that you are its owner? You have a certificate. This certificate will be given to you by the government. Okay, which means that the government is giving you certain rights. Now, I will not get into very legal technical aspects of it, but assuming, because I'm delivering a lecture in a commerce college and because I assume that you need to know a little bit about how these property rights come into picture, I just wanted to tell you there are two types of rights when you go into law. One is constitutional rights, and these are rights which are found in the Constitution of India. And then there are statutory rights, which are not there in the Constitution itself, but are there in certain acts. For instance, an act would be the Indian Penal Code, or let's say the Criminal Procedure Code, or any other act. Okay, maybe the Transfer of Property Act. But what we are talking about here under intellectual property rights is a statutory right. This right is given only under the statute, which means the government is nice enough, is good enough to give us these rights specifically for a particular reason. That reason is that it allows for the progress of science and technology, and it allows people to make economic progress. Now, for you, especially people studying commerce, your area of interest will be the economic aspect of it, right? So what happens is that when you grant people intellectual property rights, what you're doing is you are giving them a monopoly right. Okay, please focus on the word monopoly. Now, what a monopoly means is that you are the only person selling that thing. Okay, this could have a huge impact. The impact of a monopoly is also important. Now, imagine in a scenario where you want to buy a mobile phone. Okay, and the only phone available in the market is Apple iPhone. What will happen at this point is that Apple, knowing that it is the only seller of phones, mobile phones in the market, can quote any price they want. They can say that you have to pay 3 lakh rupees to buy this phone, and you have no choice but to pay 3 lakh rupees. So in that situation, you are a monopoly. Mono meaning one, poly means seller. You're a single seller in the market. And I'm sure you've all studied this under your economics paper. Now, the impact that intellectual property rights has on the market is creation of monopoly. If you are the owner of a patent, if you are the owner of a trademark, you have a monopoly over that patent, you have a monopoly over that trademark. That gives you the right to make a lot of profit out of your patents or your trademark. So therefore, in that context, it becomes important to understand what exactly these intellectual property rights are. And I've classified the intellectual property rights. We will be covering all of them, some of them in more detail than the others. So we'll start off by talking about copyrights. We'll talk about patents. We'll talk about trademarks, designs, plant varieties, geographical indications, layout designs and integrated circuits, trade secrets, and so on. Now, I will probably not have time to cover each of these in a lot of detail, so I thought I will simply cover the first four in a lot of detail, and the second four, the bottom four, we will just simply try and understand what they are. Okay. First thing is a copyright. Before getting technical about it, let me just try and tell you what it is. Imagine I ask you to draw something. Okay, I ask you, please go ahead and draw your most favorite animal. Or I ask you to write a poem. Or I ask you to write a story. Okay, and let's say I give you a week's time. So you take a week, you make a beautiful painting, or you write a great poem. And then you show it to me, right? And once I take a look at the poem or the drawing that you've made, imagine that I tear it up and throw it away. Your obvious feeling is going to be that it'll be hurtful, right? You will not like what I did. Now, after this, if I ask you that, can you please draw another painting? Can you please write another poem? You're definitely going to refuse, because you will expect that I will continue to destroy your work. This is exactly what copyright tries to prevent. Moreover, what copyright tries to do is it tries to protect your right in your work. If you have drawn that painting, if you have written that poem, then you should have the right over it. I should not be able to tear it up. Beyond simply destruction, there are other rights that you get under a copyright. Meaning, if you've written a really nice poem, maybe, okay, or you've drawn a really nice painting, somebody's going to want to buy it. And the only person who can sell that painting is the person who drew it. Which means if you make a really good painting, you have a monopoly in the market to sell that painting. Now imagine somebody like Picasso or Van Gogh or M.F. Hussain for that matter. Once they make their painting, now they're already established painters. Once they make their painting, they can quote any price they want, right? And they'll be able to sell it. So in this way, copyright has a huge impact on the economic rights of a person. Now, when you talk about what exactly does copyright cover, that is also important. What are the aspects of intellectual property that copyright covers? If you look at the Act, the Copyright Act of 1957, it says that the subject matter of copyright is original, literary, dramatic, musical, artistic works. Okay. Now, one thing I think I need to clarify at this point is because people usually are not aware of the difference between what can be covered under a patent and what can be covered under a copyright or under a trademark. So here is your basic distinction. What can you protect under a copyright? You can protect literary works. You can protect dramatic, musical, and artistic works. You can even protect cinematographic films, meaning movies, or sound recordings, meaning songs. This also includes a computer program. Okay, now when the first time Mark Zuckerberg wrote the algorithm which made Facebook, right, that was a computer program. And that computer program is the exclusive right of Mr. Zuckerberg. Nobody else can write the same computer program and build another Facebook. It is his exclusive right. And look at how he has managed to exploit the his economic rights in that algorithm. He has made millions of dollars so far. So your computer program falls within the meaning of a literary work, and thereby that is also something which is protected under copyright law. Another thing, this will be a recurring theme when we talk about property rights. When you talk about regular property rights, those property rights are in perpetuity. Meaning, if you are the owner of a house, you will be the owner until you die, and then it will go to your legal heirs, meaning your sons or daughters or brothers or sisters. But that is not the case with intellectual property rights. Intellectual property rights, because I said that the benevolent government gives you these rights, but at the same time, the government also decides how long you can have these rights for. So therefore, if you've been given economic rights, or if you've been given copyright over your work, it will be for a limited period of time, which is the lifetime of the author plus 60 years, which means as long as the author lives, he will have the copyright. And after that also another 60 years, your right in that particular work will be protected for 60 years, which means your legal heirs, whoever you leave behind after your death, will be able to earn profit from your copyrighted work. Right? And the rights that we're talking about can be classified into two types. One is the economic rights, one is the moral rights. Okay. Economic rights will allow you the right to sell, to communicate the work to the public, your right to issue copies of the work to the public, your right to give the work on rent. Okay. These are all ways in which you can make money, which is why they're called economic rights. Right? If you sell, you make money. If you rent it out, you make money. If you issue copies to the public, if you reproduce, let's say you make, let's say there is a book. Okay. If you reproduce, what you're doing is, let's say you reproduce by methods of photocopy. Right? You go to a Xerox machine, you photocopy it, and what you're doing is you're reproducing. This right is also specific to the owner of the copyright. Now, as students, I'm sure you will have the question of why then are we allowed? Because I know for a fact that every student has at some point gone to the photocopy shop and photocopied a number of textbooks, right? So are you actually committing an IPR infringement? We'll get to that at some point when we talk about plagiarism also. I'll bring that up, right? But essentially, the right to reproduce a work of copyright is an exclusive right, a monopoly right of the owner of the copyright. Okay. Then we also have moral rights. Moral rights will cover those acts like when I tore up your poem or your painting. Okay. Moral rights restrict other people from destroying or damaging your copyrighted work. Okay, so these are the two kinds of rights that you get under a copyright. Now, to look at it more closely, what exactly is the subject matter of a copyright? We talked about the fact that it has to be original, right? For anything to get copyright protection, there has to be originality. What does that mean? When we talk about any kind of intellectual property, we are referring to a situation, or we are referring to a property that has been created out of our minds. It has to be a work that has been created from our intellect, right? That is why we call it intellectual property. So something that comes from our intellect is intellectual property. What does it mean when we say that it has to be from your intellect? When I say that I should have a copyright over the story that I wrote, the reasoning behind this is that I have put in efforts. This story has come from my mind, and therefore I should have monopoly rights over the work. But at the same time, if you say that, if it is a story that you have basically copied from another person, right? I'm sure everybody has heard of Harry Potter, let's say. Okay, Harry Potter is a very famous novel series written by J.K. Rowling. Now, J.K. Rowling has written that book on her own. Now, let's say tomorrow I write another novel with the same plot as that of Harry Potter, and I say that this is my work of copyright. That will not do, because it did not come from my intellect. I have copied it from somebody else. So, a very, very important element that you need to make sure is there is that it is original. Okay, original meaning you have not copied it from anybody else, it has originated from you, the author, right? So that is basically what original means. Now, original what exactly? Literary works like books, your poems, or any kind of notes, even question papers. Okay, if there are teachers listening into this, if you've prepared a question paper that is completely original, okay, you have come up with the questions, you have put in the words that are necessary, then that could potentially be an original literary work which you can protect. Okay, again, computer programs. If you have friends who are coders, maybe you have friends who are doing software engineering, if they're writing code, if their code is original, then they can protect it as literary works under copyright. Then we also have dramatic works. Dramatic works as in, let's say, the play of Shakespeare. Okay, now these plays are those things which can be performed on stage, right? Live on stage, but is in a written form. So dramatic works are also something that you can protect under copyright. Then you have musical works. Meaning, let's say you sit down with a guitar and you start playing a tune and you think, okay, this is a really nice tune, I'm going to record it. Now, if somebody has studied music, in theory, you know that you can actually record music on a piece of paper by writing it down. Right? It's called sheet music. People read from sheet music. Now, once you've written it down on a piece of paper, that essentially means that you have a musical work. Okay? So that is also something that you can protect as a copyright. Then you have artistic works. Artistic works could include anything from a painting, a drawing, blueprint of some building. It could even be a photograph. Right? All of these things come within the meaning of artistic works. It could be a sculpture, it could be engravings. So a lot of things come within the meaning of artistic works also. Then we have cinematograph films, which is movies. Right? Any film that you watch is a cinematograph film. A cinematograph film could also be one of those YouTube videos that you watch. It doesn't necessarily have to be a movie. Anything which has audio and visual in a recorded form is a cinematograph film, which means that if you take your phone out and you start recording an incident, you are creating a cinematograph film. Okay, so all of those videos that you make with your friends when you're sitting down and you are recording them, all of those are cinematograph films. Okay, and if it is original enough, then you do have the right of monopoly over that cinematograph film. And finally, we have sound recordings. Now, you might ask, we've already covered musical works. Why are we talking about sound recordings again? There's a difference. When we talk about musical works, we're only talking about the musical aspect, the tune. Whereas in a sound recording, this would also include your lyrics, your other sound arrangement, and most essentially, it will be in a recorded form. Meaning, it can be played. If you press play, the music will play. But in a musical work, you would have written it on a piece of paper. It would be sheet music, which represents the music that you've come up with. Right? So this is essentially what the subject matter of a copyright is. Now, when we talk about originality, I've already told you, it comes from the word origin, which means it must originate from the author, and the work must not be copied from another person. It should have originality, meaning it should come from you. It should not have been copied from another person. But what is the problem in this situation is that you can't be expected to have a completely original work. If, let's say, I ask you to write a story today, or I ask you to make a movie today, your movie is going to contain certain elements. For instance, your movie is going to contain elements where maybe there is a boy and a girl who fall in love. That is the plot of almost every movie. Even if the larger story is something else, this subplot is definitely going to be there, right? Or it could be about a person who is going through a struggle, and the story is about how that person has overcome his struggle through his hard work. Now, if I tell you this plot, a number of movies will come to your head, right? Or let's say the movie is about horror. There is a ghost. If I say a ghost, the element of ghost is going to be there in a number of movies that you've watched. Does that mean they're not original? No. The degree of originality which is required to obtain a copyright is not very high. Which means to say that if your work, let's say your literary work or your artistic work, has a certain amount of originality, meaning you have not copied from anybody else, that is sufficient to say that it is an original work. Okay. All right. We're moving on to patent. I would have liked a little bit of feedback on whether you have questions, but it's all right. I mean, please post your questions on YouTube Live. I'd be happy to answer them. And since I'm supposed to be covering a lot of these things, a lot of the IPRs that are available, I'm just going to quickly move on to the next one, which is patent. Very interesting. And I'm sure whenever somebody talks about intellectual property rights, the first thing they mention is patent, right?
Right now, we do not have any questions, madam.
Okay.
Once we get the questions, I will update.
Okay, sure. Okay, so coming to patents. Now, what can you protect as a patent? Because under copyright, we just saw that you can protect your literary works, dramatic works, artistic works, musical works, cinematograph films, and sound recordings. What do you protect under a patent? You protect inventions. Okay, now you might ask, how is it different? An invention is completely different from what you protect under a copyright. An invention has a much higher degree of originality, which we call as novelty. Meaning, an invention will be something which has never been created before. Okay, so what we're talking about when we say something is an invention is that it is something which is novel, meaning nobody has ever been able to create it. And it must have utility, meaning there must be some use of it. Okay, and it should have an inventive step plus disclosure. Now, these are all, it'll become very legal and technical if I go into all of these. But let me just tell you that invention, the most classic example of an invention would be the light bulb. And if I asked you who invented the light bulb, it would be Thomas Edison, right? Now, this person has invented the light bulb. In retrospect, it doesn't look like much. Every one of our houses has a light bulb. We have tube lights, we have LED lights, we've advanced so much. But if you look back at the time when it was invented, all people had were candles. Okay, and nobody had ever heard of something called a light bulb. More precisely, nobody had ever heard of something called electricity, right? So imagine the inventor's innovation and the hard work that he has put in to make sure that the electricity which he has seen in the lightning is harnessed and is put into filaments in a light bulb, which makes it light up. Okay, and that the light bulb is essentially considered to be the first invention capable of being patented. Okay, and that is why whenever, I mean, the whole idea of when people say idea, there is a light bulb, right? I'm sure you've seen it in comics. Whenever somebody gets a good idea, they show a light bulb. The relation is with Edison inventing the light bulb. So what we are talking about under a patent, or rather an invention, is something which is absolutely new, has utility. The light bulb definitely had a lot of utility. It helped people, function in the dark after sundown, right? And also, uh, any form of inventive step. Now, inventive step becomes a little more technical. This here you would have to prove that there is some kind of advancement in technology or economic ease. Okay, if your invention is something which has which is a step forward in the technology that is available, or it is something which has some form of economic significance, maybe the cost of production has come down, maybe you're able to manufacture more units of a particular product, that would involve an inventive step. Now, I can go ahead and give you a number of examples of what would constitute an invention. Okay, let's start with medicines. Okay, now the most common medicine that you would take when you have a fever is paracetamol, right? As soon as you get a fever, you look for paracetamol. Now, this could come, the element of paracetamol will come in a number of medicines. It would, I mean, there is Decold, there is Calpol, there is, so many of these things. Dolo 650, which is probably the most common one now that people are getting vaccinated. But right now, paracetamol is very easily available. The problem was, when paracetamol was invented, it was completely new. Nobody had ever heard of it, and it was very useful. It had a lot of utility because people were falling sick, and fever was, it's a very common cold, which means that you need to take something. If something can help you get over that fever, it has a lot of utility. And definitely, it had taken a step forward in terms of technological advancement. Another example is the seat belt. The seat belt in your car. Okay, the airbag in your car. These are all patented by the company Volvo. They've innovated, they've come up with more safer environments to drive a car in. Okay, before the seatbelt came into picture, it was completely new. Nobody had ever heard of it or even thought of a system by which you can strap yourself into your car seat so that if, in the case of a car crash, you don't go out flying, right? Airbags, that in case your car hits something, your head doesn't completely hit the steering wheel or the windshield and you don't suffer any injury. So there is an airbag. These are things that people have innovated. They've thought from their minds and they've come up with these systems. And therefore, again, the government is gracious enough to give some form of proprietary rights over these inventions. Again, the term here is different. The term for which you can protect a patent is 20 years. That is it. Okay, now copyrights would seem much more lucrative, much longer term for protection. Okay, what exactly I mean by protection is that you continue to have monopoly rights. So for 20 years, if let's say today you have invented something, okay, most current hot topic is the COVID vaccine, right? We have Covishield, we have Covaxin. Let's say Covaxin, homegrown Indian, Covaxin created by Bharat Biotech. Let's say you are the owner of Bharat Biotech and your scientists have invented the Covaxin, COVID vaccine. This is completely new, first of all, right? Of course, simultaneously, other people have come up with similar vaccines, but at the time that Bharat Biotech came up with it, it's completely new, which means there is novelty. Utility is definitely there because people want to get vaccinated, and there is an inventive step because so far, nobody had any clue how to cure COVID or even, be protected against it, which means it has fulfilled the criteria. Now, what happens is if Bharat Biotech gets a patent over Covaxin, they will be the monopoly sellers. They will be the only people who have control over the supply of Covaxin in the market. Why do you think Covaxin is so high priced? To demand around, I think it's 1200 rupees right now, It's because Bharat Biotech has monopoly over it. Nobody else knows how to make the Covaxin vaccine, which means Bharat Biotech, being the only people who know how to make the vaccine, are the only people who can manufacture it and sell it. Therefore, they get to make a lot of profit at this point. And if somebody figured out, okay, let's say somebody took one vial of the vaccine, sat down for months and figured out how to make that vaccine, they still would not be allowed to, because Bharat Biotech would have a patent over it. What this essentially means is that Bharat Biotech is the only company that can manufacture Covaxin, unless, of course, they give it on a license to other people. Now, that right is also completely theirs. They can decide who they want to give a license to. And a license means more money. Okay, they're definitely not going to give out a license for free. They're going to give a license to another company to manufacture the Covaxin in exchange for a sum of money. So, therefore, this becomes important. Now, the term of 20 years, if I try to justify the term of 20 years, how this works is that you cannot have a patent forever, and the government or the legislature has felt that 20 years is enough for a person to exploit his patent rights. After that, it comes into the public domain. Now, when you look at paracetamol can be manufactured by anybody. All these companies, Cipla, Cadila, are all manufacturing paracetamol infused medicines, which means the patent over paracetamol has expired. The 20 years for which the monopoly over paracetamol was there is over. And after 20 years, this comes into the public domain, which means everybody can now use it. Okay, so what does your patent right give you? It gives you the exclusive right to use the invention, to make the invention, to sell the invention, and to distribute the invention, which means you have a lot of control over how your invention goes out into the world. Okay, so patent is basically a monopoly right conferred by the patent office on an inventor to exploit his invention subject to the provisions of the Patent Act for a limited period of time. So what you have under a patent is a monopoly right. I think I've already explained what a monopoly right is. You are the sole seller or manufacturer of that particular invention. This right is given by the government through the patent office on the inventor to exploit his invention. Exploit economically, obviously. Exploit in the sense you can make as much profit as you want out of that particular invention, subject to the provisions of the Act. Of course, there are certain terms and conditions that you must follow, and this will be for a limited period of time. During this period, the inventor is entitled to exclude anyone else from commercially exploiting his invention. Now, what you get as a right is basically you have the right to exclude everyone else, which means if at this point anybody else, let's say some other pharmaceutical company, let's say Cadila Pharmaceuticals decides that they also want to manufacture the Covaxin. They figured out how to make the vaccine, so they're also trying to manufacture Covaxin. At this point, Bharat Biotech can go to court and ask the court to stop Cadila from manufacturing the same vaccine. Okay, this is the reason why there is such a hue and cry right now about vaccines and patenting of vaccines, and India has gone to WIPO along with South Africa asking for a waiver of patent rights. So a lot of problems are involved in how the exclusive right is to be protected. And I mean, of course, there is also a question of how public interest needs to be protected at the same time while you're protecting the monopoly right of the inventor. Because yes, Bharat Biotech did put in a lot of effort into creating that vaccine, but India is a poor country. Not everybody can afford a 1,200 rupees vaccine. So these are issues that need to be resolved at the government level. But what I'm saying is that this is the right that you get under a patent. Okay, it is a statutory monopoly which protects the patentee against any unlicensed user of the patented device. Anybody without a license, if they're creating the invention for which you have a patent, you can go to court and you can stop them. The court will stop that person from continuing to use, which means you continue to be the monopoly. You continue to be the sole seller in the market, which means your pricing of that particular product can go as high as you want. Of course, you are going to think, okay, I mean, you might wonder, why did Bharat Biotech just stop at 1200? Why not more than that? They can even charge 5,000 for it. It has to make sense. If they price it at 5,000, nobody's going to take it. Right? And also because at this point, they have some form of competition in the form of Covishield. Covishield is priced a little lower. So they had to price it in a way that made sense, that they want to make a lot of profit, and at the same time, they have to make sure that people still take Covaxin, right? So to that extent, I mean, to sum it up, this is basically what a patent is. I mean, if you look at the meaning of a patent under the Act, it says patent means a patent for any invention granted under this Act. And I have a few examples of patent here. Back in 1890, the first bicycle was patented. And this is how they, in the patent application, this is how they described what the invention was. Imagine a time when there was no bicycle. Okay, and somebody came up with the idea that if we put two wheels together and we, make a seat here, then somebody can sit and pedal their way and, travel faster. And therefore, somebody got a patent over it back in 1890. Then, of course, we have the light bulb and all forms of medicine. Medicine is currently one of the most major areas in which patents are being filed, right? This control of disease is something which is heavily invested in. People invest a lot of money into the pharmaceutical industry because it's one of the priorities for any kind of society, right? We need to be able to prevent diseases and cure diseases. So there's a lot of money involved in the pharmaceutical sector. And if you can come up with a new cure for a disease, that will earn you a lot of money. Now, when we talk about an invention, again, legally speaking, it means a new product or process, which means there must be novelty. No one must have ever heard of it. And it must involve an inventive step, which is also capable of industrial application. Right? So that is basically patent law, patents for you in a gist. And when it comes to the violation of a patent, what I just said is what violation is. If Cadila decides to manufacture Covaxin, they are essentially violating the patent rights of Bharat Biotech. Okay. So whatever the exclusive right of Bharat Biotech is, if anybody else tries to do those things, like make the product or sell it or import it, all of those things are things that only Bharat Biotech can do with respect to Covaxin. And if anybody else does it, they are violating the patent rights of Bharat Biotech. Okay, I can see that I'm running out of time, so I'm just going to go really quick on this. The next kind of IPR that we have is trademarks. Okay, and this can include a lot of things. It could be a brand, a heading, a label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, combination of colors, or any combination thereof. Essentially, what a trademark should have. When can something be a trademark? It should be capable of distinguishing the goods of one from those of another, plus it should be capable of graphical representation. Now, I will not go into too much detail here at this point. I will show you the next slide, which will make sense to you. But before I get there, term. Copyrights was life of the author plus 60 years. Patents was 20 years. Trademarks is 10 years plus renewal, which means once you apply for a trademark, you have to apply to the trademark registry saying that I am the owner of this trademark. Please give me a certificate saying that I am the owner of this trademark. which means you will be the owner of that trademark for 10 years. After that, you have to renew it. How do you renew? You make another application and you pay a fee. So once you renew it, again 10 years, you get protection. Again, at the end of 10 years, again you file for renewal, right? Which means you can basically be the owner of a trademark forever, for perpetuity, as long as you keep renewing it. Now let's try and see what trademark is. Okay, for something to be a trademark, it has to first be a mark, right? Now, I'm sure you've come across these trademarks. This right here, the colorful band, is the NBFC logo. It's a TV channel. And this, I'm sure a lot of you have seen. If you're fashion conscious, I'm sure you've seen Chanel, right? It's a luxury brand, and it is, it's basically a brand, right? So it can be a device like this, device meaning anything which is a drawing, okay? Or it can be a brand like Chanel. It can be a label like the Levi's. If you've bought a pair of Levi's jeans, at the back pocket you will find a red label with the word Levi's written on it. It can be a name like Audi, or it can be a name like Tata, or Indian name from the Tata family, or it can be a signature. This is Sachin Tendulkar's signature. This has also been used as a trademark. Okay. It could be a word like Pepsi. It could be a letter like M of McDonald's. It could be a numeral like 8 p.m. It could be the shape of goods. The shape of goods, of course, okay. Let's say Coca-Cola bottle. I'm sure you've all seen the Coca-Cola bottle, the glass bottle. Okay. The glass bottle of Coca-Cola, the shape itself is the trademark. Okay, which means no other company can make the same shaped bottle. So if you look at the glass bottles of Pepsi, they're a little different from how the Coca-Cola bottle looks, right? Pepsi, Thumbs Up, Mirinda, all of them will have similar looking bottles, whereas Coca-Cola has a specific curved glass bottle, right? Then it could be the packaging or combination of colors. For that, I've given the example of this thing. I don't know if you've seen it, but this is Tiffany and Co. Recently, okay, this happened, I think 2 years ago. I don't know if you've heard of Nick Jonas and Priyanka Chopra. I'm sure you've heard of Priyanka Chopra at least. So Priyanka Chopra recently got married to Nick Jonas. Now, when Nick Jonas proposed to her, he took her to a shop called Tiffany and Co. It's the biggest jewelry brand in the US at least. Okay. Now, Tiffany and Co. is where everybody gets their engagement rings from. And they have a very peculiar looking or very distinct looking packaging. Their box in which the ring comes in is this color of blue. And you wouldn't believe me, they've even trademarked the color. It's called Tiffany Blue. Nobody else, no other product can sell their goods in a box, in a package which has this blue color. Right? So Tiffany and Co. has a trademark over the packaging itself. Okay. It could also be a combination of colors. I think this is a very familiar trademark for you, the Pepsi trademark, which is a combination of red, white, and blue. Right? So nobody can actually have this the combination of red, white, and blue drawn exactly like this as a trademark over their product. Okay. And it could be any combination thereof. So any combination of maybe name and numeral, it could be a combination of word and letter. So any combination can be a trademark. Now, why exactly are we talking about trademarks, and why should you even trademark something? Let me try and explain this to you with the help of a story. Okay. Now, let's say that I open a store. Okay, I have opened a shop in which I am selling clothes, and the name of my shop is Simona. So on top, every shop has the name written on top, right? So I've written Simona like this in the same font, underlined. I've written it on top of my store. Now people come into my store and they like the product that I'm selling. They like the clothes that I'm selling. A lot of them buy it. and I'm really sweet to them. I have great customer service. And then they go home, they buy those clothes, they go home, they wear those clothes, and they go out. And their friends ask, oh, where did you buy it from? So they say that there's this shop called Simona where we bought these really nice clothes. So these friends also come over to my shop and they also buy clothes from my shop. And this is basically how business works, right? You need to have good quality products which will make people talk about it, and by word of mouth itself, people are going to come and buy your product. Now, I put in a lot of effort. I make sure all my clothes are top quality. I make sure that if somebody finds a problem in those clothes, I replace it instantly, right? So there are a lot of good qualities in my shop for which it has become very popular. Now, in the next city, somebody opens a shop which sells clothes and also calls it Simona. Okay, but they've written it in this way. The font is a little different, which means that people are going to go into that shop thinking that it is the original Simona which they went to in the first place. Because my popularity has been growing, so people simply now trust the word Simona. When they hear Simona, okay, this is a great shop, we should go buy from here. So in the next city, when they see this shop which is called Simona, they might not focus on the font so much. They're just looking at the word, right? So they go in and they find that, okay, not great clothes. I mean, the clothes aren't very good quality. Customer service is not good. The salesmen are a little rude. And so they come out and they're not satisfied. Now the problem is, because these customers have gone home dissatisfied, this also they're going to tell their friends. They're going to say that, okay, I mean, Simona has probably become a little bad. I mean, the quality of that shop has come down. Okay, and this will spread, which will ultimately have the effect of, harming me. Because people will stop coming to my shop thinking that my shop has also lost its quality, right? This example I'm using to show you the importance of a trademark. The fact that I decided to call my shop Simona and somebody else is also calling it Simona has this butterfly effect, that the reputation of one shop is affecting the another. And also, it is affecting the consumer. Because the consumer, when they went into the second shop, Simona, they were actually intending to go into the first one. Now, they have been deceived into thinking, the consumer has been deceived into thinking that the second Simona shop is actually the first one. So here, there are two parties who are being affected. It is the seller and the consumer both. Okay, so when we talk about a trademark, you are basically protecting both the seller and the consumer. Now let's imagine another scenario. Okay, imagine that you're going to buy cooking oil. Okay, maybe your mother has asked you to go, she's given you a 100 rupee note and she says, go buy cooking oil. Okay, now you don't know which cooking oil that your family buys. So you go into a departmental store and you look at the shelf. Okay, you go to the shelves where all the cooking oil is there. Now you see these options. You have Freedom, you have Fortune, you have Engine Oil, you have Saffola, and you have Del Monte olive oil. Which would you prefer? Now, if I asked you individually, you would all tell me different things, right? Somebody might say that engine oil. Why? Because I know that my mother uses engine oil, or I know that we use mustard oil mostly, maybe because of that. Or somebody might say Freedom oil. We've been using it for a long time. Another person might say Fortune, because I've seen a lot of ads on television. Another person might say Saffola, because it's supposed to be a healthy oil. Or somebody might say Del Monte, because I only want to eat food made in olive oil because it's supposed to be better for your heart. You will all have your reasons for buying whichever cooking oil that you prefer. The point here is, you are able to differentiate between each of them only because there is a name on it. If it was just the packet, would you be able to tell the difference between Fortune and Saffola? If there was nothing written on the packaging, would you be able to tell the difference between Freedom and Engine? The reason we have trademarks is to allow the consumer to tell the difference between different brands of products. Okay, so what we are doing is we are protecting two kinds of people. We are protecting the interest of the producer or the seller, because in the first instance, I showed you how the seller might end up losing out if others start using the same trademark. And in the second instance, it is the consumer. When you go to the shop, you should be able to tell which cooking oil you want to buy. Okay, for a variety of reasons. You might think, okay, I saw this in an advertisement, it's supposed to be good. The only way you can relate the advertisement to the actual cooking oil that you see is through the name. Otherwise, how will you remember which cooking oil it was? Right? So to that extent, under a trademark, what we're protecting is both the producer and the consumer. Moving on to designs. Okay. Designs is again something which we protect as an IP because of how it helps a product become attractive. Okay. Now, again, your commerce students, your motivation, your objective for any kind of transaction is to make sure that whatever product is being sold, you make a profit out of it and that more and more people buy your product. Right. So in this regard, when you are selling something, any product that you're selling, let's say you're selling water bottles. Okay. Now, a very well-known name or brand in the water bottle industry is Tupperware. If you go to buy water bottles, you're simply going to go buy a Tupperware. What about the 10 other sellers of water bottles that are there? How do they make sure that the consumer decides to buy their bottle instead of Tupperware, which is already well established? What they can do is they can make the water bottle look really attractive. Okay, which means they're going to somehow introduce elements into the water bottle which will make it look appealing. That aspect, which just changes the way in which a particular product looks, is called a design. It is those features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article. This is all technical. We'll come to the bottom, which in the finished article appeal to and are judged solely by the eye. So when you look at something, if the product is appealing to the eye of the consumer and it adds commercial value to the product. So like I said, the reason for introducing new designs is to add commercial value to the product. Then that is something which you can protect as a design. Now, again, when it comes to the term of protection, here also it is 10 years plus renewal, same as designs. Okay, so what exactly are we talking about when we refer to a design? It could be a shape of goods, like the Coca-Cola bottle. You can even protect it as a design law. You can also protect this particular shape. It's a chair, right? Every chair looks the same. It has a seating area and two side handles for your hands to be kept on. But not every chair looks like this. There are certain unique elements about this chair. There is a gap at the and the middle part is a little bent in, which probably adds to seating comfort. It is in a square shape, which is also a unique shape which has been introduced. And this is something that you can protect as a design. Then you have configuration, which is basically the same thing as a shape because it depends on how the product is configured, right? What goes where and how it is configured is something that can be introduced as a concept of a design. Then you have patterns. Okay, I mean, patterns is something, it's a design that is most commonly seen on clothes. If you look at, I'm sure you've heard of Sabyasachi, Anushka Sharma recently getting married to Virat Kohli in a Sabyasachi lehenga, right? So Sabyasachi is one of the most famous fashion designers in India. Now, his clothes, if you look at the one that is on your screen, has a certain pattern on it, right? It has a repetition. Whenever there's a repetition of the same thing, it's considered to be a pattern. And just a bit of trivia for you, Sabyasachi Couture, which is the company which Sabyasachi runs, became the first design house in the country to win the National Intellectual Property Award in the year 2018 for being the top Indian company organization for designs and commercialization. So this company, Sabyasachi Couture, has filed for the maximum number of design applications over the designs that they have created, and that is why they've been awarded the position of top Indian company organization for design and commercialization. Then you have ornament. An example of ornament I've added here is on cutlery, anything that you do, any carvings, any engravings that you do to make it ornamental, or it could even be a handbag. Let's say you have a handbag on which there are pearl embellishments or zari work. All of that is ornamentation. Okay, and that is also the ornamentation on a particular product which makes it appealing is also considered to be a design. And finally, we have composition of lines and colors. If you look at the tire here, you would think that every tire looks the same, but no. The lines and the lines that are drawn over each tire is different. Okay, and they do this, the lines that they draw are meant to actually appeal to the eye of the consumer. Although I am sure nobody would actually buy a tire because it has attractive lines on it, but rather because you trust the brand. Yet the sellers of tires keep trying to innovate and put in their efforts to make sure that the tires look attractive. Okay, all right, I know I'm running out of time. I'll quickly go through. Ma'am, Nandini ma'am, if you could tell me how much more time I have.
Madam, you have time, madam. You can continue. You have some more time. No problem. No issue with the time. You can continue.
Okay, great. All right. So the next type of IP that I wanted to talk to you about is plant varieties. And this is especially important. This kind of IPR is especially important in a country like India. Okay, because what we're protecting is new plant varieties. And why this comes into picture, especially in the context of India, is because we're an agrarian country, right? Our economy depends a lot upon the agriculture, which is why we treat farmers with so much respect. We have to give them priority. We try to ensure that the rights are protected. And one of the ways in which we protect farmers' rights is under this very act called Protection of Plant Varieties and Farmers' Rights Act. Now, what we are protecting here is new plant varieties. Let's say you sow seeds of rice, right? Growing rice is something which is very common. I think it's in the South also, it's pretty common. Rice is one of the staple food here, right? Now, there are a number of different kinds of rice, right? Forgive me, I'm not very good at it, but I know there is Sona Masuri, there is Basmati, there is, I'm forgetting, but yeah. So there are different kinds of rice. Now, every kind of rice will grow differently, will produce different amount of rice, right? So sometimes what might happen is a farmer might be sowing a lot of rice seeds. And when the time comes, the harvest is very small. Okay, so what happens is the farmer ends up losing out. He put in so much effort, he bought seeds, he bought a tractor to cultivate his land, and he worked so hard on, reaping all of that rice. But ultimately, he gets very little. This is a problem, right? So what we need to do is we need to make sure that the type of rice seeds we're sowing or the rice plants we're sowing have a high yield, will give more produce. Therefore, it is encouraged under this act as a form of IP that you create new plant varieties, right? This is also something that scientists do. They will sit in their labs, they will try to understand the genetic makeup of that plant, they will try to introduce new elements to it, which will enable the plant to grow more. An example, the picture you see on your screen right now is an example of something called a BT cotton. Okay, this is one of the most famous cases of plant varieties where so we have the cotton plant, right? The cotton plant is very susceptible to something called an American bollworm. Okay, it's an insect, it's a pest which eats up the cotton plant, and thereby the yield or the produce of the cotton plant becomes low. Okay, now there is a company called Monsanto, and what they did was they introduced a new kind of cotton plant called the BT cotton plant, wherein they have inserted a certain technology which kills the American bollworm, or rather makes the plant itself resistant to the American bollworm. So the pesticide basically has been inserted into the cotton plant itself, which means currently this is a new plant variety. Okay, so this plant variety has been given protection under the Plant Varieties Act. And in that context, all I'm trying to say is that it is important that we protect and recognize the efforts that go into creating new plant varieties, especially in our Indian context, wherein we need to make sure the crops or the plants that we're growing are the best ones, are resistant to floods, droughts, pests, and still continue to give a high amount of yield. Now, again, when you talk about the term of protection, if you're somebody who's created a new plant variety, your term of protection is, if it's field crops like rice, wheat, barley, etc., the term of protection will be for 15 years, and for trees and vines, it will be for 18 years. So again, I mean, the protection basically entails that if you have created a new plant variety, you have monopoly rights over it. You are going to be able to, you will be the only person who is selling the seeds to that new plant variety, right? And thereby again, you will be making profits. Then you have something called geographical indications. The geographical indication is very, very similar to a trademark, except that instead of using just any name, number, numeral, etc., we will be specifically using the names of places. Okay, what this does is, the effect of this is, it tells people where a particular product is coming from. So on your screen, you have the picture of Darjeeling tea. This is basically the logo of Darjeeling tea, which means, see, Darjeeling tea is famous, okay, for a reason. It has a certain aroma, it has a certain taste, and it is famous worldwide. India exports a large amount of tea, that is Darjeeling tea, to the UK. Now, naturally, this means that if you sell tea, okay, today, let's say I grow tea in Bangalore and I put it in a packet and I write Darjeeling tea on it, I can sell it at a much higher price, because people think that, I mean, people know that Darjeeling tea is good tea, okay, whereas it is actually, the tea that I am selling has not been grown in Darjeeling. Right? So what we are trying to protect as geographical indications is this. We are trying to tell the consumer correctly where the particular product comes from. Okay? In the same way, we have examples of, let's say, Nagpur oranges, right? Or Kolhapuri chappal, or Mysore silk sari, or Mysore sandalwood. So a lot of these things, see, why is Mysore silk sari so famous? Because people know it's a good quality sari. Okay, if I start to sell any sari and I call it Mysore silk sari, that will be a problem, because I'm lying to the consumer that this is Mysore silk. Unless it is actually Mysore silk, I do not have the right to sell it as Mysore silk. So therefore, what we're doing here under geographical indication is that we're protecting these people, the actual sellers of Mysore silk in Karnataka who sell Mysore silk saris, we're protecting them. We're saying nobody except these people will be able to sell saris under the name of Mysore silk. Okay. And of course, I mean, geographical indications basically indicates that particular goods originate from a country, region, or locality and has some special characteristics, qualities, or reputation which are attributable to its place of origin. Now, what is important for us to understand is that when we refer to a product by the name of its place, it is because that particular product has become famous because of, by virtue of the fact that it is the place where it comes from. Meaning that if, let's say, we're talking about Nagpur oranges, right? Now, Nagpur oranges are famous, are being sold, are being exported, are being sold at such high prices because it tastes a particular way. The taste of Nagpur orange, the size of the Nagpur orange comes from the fact that it is being grown in Nagpur. Oranges grown anywhere else will not have the same characteristics as that of Nagpur orange. Therefore, to make sure that the consumer is protected and also the seller is protected again, we protect geographical indications as intellectual property of those people who are selling these things in that place itself. So nobody outside of Darjeeling will be able to sell tea under the name Darjeeling tea. Nobody outside of Karnataka will be able to sell silk by the name of Mysore silk. Right? Again, term of protection is same as that of trademarks. It is 10 years plus renewal. So every 10 years, if you keep renewing it, your protection keeps on increasing. So any person, if let's say today I start selling saris under the name of Mysore silk, I will be infringing upon the geographical indication rights of the owners of the GI. Okay, then we have layout designs and integrated circuits. This is again, I mean, if you've seen the motherboard of a computer maybe, or if you've seen the inside of a mobile phone, okay, if you try to take out the batteries and look at it, look at how it works, you will see that it is actually, I mean, very intricately designed, right? Small wires going from here to there, right? Circuits being built, one circuit being connected to another. And therefore, the entire layout of this particular integrated circuit is something that is being protected as an IP. Okay, I'm going to quickly move on to plagiarism. I guess I don't have time for these. So one thing that I was supposed to cover under today's topic is the topic of plagiarism. And very important, especially for students as well as academics, whoever is trying to do any form of research, right? Plagiarism is basically considered to be theft of intellectual property, right? And this has been around, the theft of intellectual property has been around for as long as humans have produced work of art and research. So even from the times of early men, I'm sure if somebody drew something on a cave, then another man would have drawn a similar thing on another cave. So theft of intellectual property. Now, if you look at plagiarism, we're basically referring to plagiarism in terms of literary works, right? Plagiarism happens when you copy an article, maybe a research work of somebody else. So therefore, plagiarism is very closely linked to copyrights. Okay, when somebody writes a research paper and you copy the entire research paper, you are committing copyright infringement, and at the same time, you are also committing plagiarism. Plagiarism is a shorter or smaller subsection of the umbrella term infringement. Okay, now what exactly constitutes plagiarism? There are several instances. One would be turning in someone else's work as your own. Okay, somebody else has written a paper or an assignment and you are submitting it to your teacher as your own work. This is plagiarism. Secondly, you are copying words or ideas from someone else without giving credit. And this is one of the most common practices in today's world. Any assignment given in any college, I mean, I know that I have also gone through this stage where, I mean, if an assignment is given to us, we simply Google the topic and we find similar articles on it and we copy paste it, right? So what we're doing right now is we are copying words or we are copying the ideas that somebody else has written and we are not giving them credit. We're trying to say that this is something that we have written, right? So what we're doing is we're plagiarizing. Thirdly, if we're failing to put a quotation in quotation marks, or we're giving incorrect information about the source of a quotation. Okay, let's say I want to write a statement which somebody else has said. I have to put it in quotes and describe who the author is. If I fail to do that, I am plagiarizing. I am using somebody else's words as my own. Or if I am giving incorrect information about the source of a quotation, if there is something that has been said by one person, okay, let's say principal madam has said something and I want to use what she has said in today's speech, and instead of writing her name, I have put Nandini madam's name as the author of that quotation. This is again, I'm giving incorrect information about the source of the quotation, and that again constitutes plagiarism. Again, changing words but copying the sentence structure of a source without giving credit this is something which we call as paraphrasing, right? We know that we will get caught if we completely copy paste, so we change the words here and there, but we are still copying the sentence structure of somebody else without giving them credit, and what we're doing is plagiarizing. Or we could be copying many words or ideas from a source that make up the majority of your work, whether you give credit or not. So let's say you are writing a research paper, and out of the 7 pages that you've written in your research paper, 6 pages is just copy paste. Only 1 page you have written on your own, that is the conclusion. That is very general practice in a lot of places. Okay, that is actually constituting plagiarism. You are copying, you are stealing the work of somebody else and not giving them credit for it. Now, why do people do plagiarism? Why does it actually happen? First reason is it could be accidental. Okay, because people don't know about it. People don't understand that you're supposed to give credit to people when you copy from them. Or maybe people don't know that the concept of plagiarism exists. People don't even realize that it is actually wrong to copy somebody else's words and ideas, right? So it could be accidental. It could also be unintentional, meaning that, there is so much information available right now, right? If I want to write a paper on accountancy today and I Google accountancy, I will get multiple books, and all of those multiple books have similar information in them. Right? And if I want to write another book, I will end up writing similar things only. So in this situation, the plagiarism might be unintentional, where I have probably not tried to copy it, but what I've written sounds very similar to what is already written in some other book. So this would be an unintentional form of plagiarism. Thirdly, it could be intentional, where you know that this is what you're doing is plagiarism, but you can't help it. You don't have time maybe to come up with your own original work. So what you're doing is you're simply copying somebody else's work, and you're not giving that person credit. You are taking credit for whatever that other person has written. And finally, there is another way of plagiarism called self-plagiarism. Let's say you have published a particular article somewhere, okay? And after that you are writing another article wherein you are copying the same work, same things that you have written in your previous article. So what you're doing is you're plagiarizing yourself. Okay, you are not referring to the fact that this paper has already been published, and all you're doing is you're copying your own work, and that constitutes self-plagiarism. Now, there are several methods of plagiarism. I will not get into it in detail. You could copy paste, like I've already said. You could plagiarize the idea only. You might change the words, but you might copy the idea. You might paraphrase. You might there might be artistic plagiarism, wherein you use somebody else's work using different media. Maybe somebody has hand painted something, some work, and what you are doing is you are drawing it digitally. So you've changed the media, and therefore you are committing artistic plagiarism. There could be code plagiarism, where, like I said, computer programs or code is something which is a literary work. And again, if you copy that, that becomes code plagiarism. So yeah, there are several methods of plagiarism that can happen, but we need to understand the consequences of plagiarism. The reason why plagiarism is so rampant is because the consequences of plagiarism are not well defined. We have a system of copyright protection wherein we have a system of protection of copyrighted works, and we call it infringement if somebody copies or reproduces works. But plagiarism is not the same as copyright infringement, because copyright infringement would include reproduction of the work, issuing copies, communicating the work to the public, or selling the work. Here, what you're doing is you're not selling it. You're not making any commercial benefit out of it. Plagiarism is simply used in a way wherein you take credit for somebody else's work, right? So to that extent, the consequences of plagiarism are not well defined. But there are many universities in India which have a well-defined policy to classify and deal with academic misconduct. The act of plagiarism is considered to be academic misconduct. A few years ago, one of the vice chancellors of a big university, I don't want to take names, but one of the vice chancellors of a big university in India was suspended because they found that a number of his articles were actually plagiarized. Okay, so it is considered to be a serious academic misconduct. It is looked down upon, but we don't have a legal framework to deal with plagiarism. However, each university has its own way of dealing with these things. And currently, with the advancement of technology, we have plagiarism detection softwares like Turnitin, Urkund, Copycat, etc., wherein if you just upload the article, the software itself will tell you what percentage of the article is plagiarized. So there are now ways in which plagiarism can be detected. It is getting better every day. One problem with these software detection, plagiarism detection softwares, is that they're very expensive. Individuals cannot afford. It is unreasonable for individuals to buy these. It is only institutions that can end up buying plagiarism detection softwares. But it works to the extent that you can catch hold of people who are plagiarizing the works. And individual penalties can be imposed by teachers, including written or verbal warnings, failing or lower grades in extra assignments. These are practices that every institution carries out, wherein these kids are reprimanded. Anybody who plagiarizes is actually condemned, and they're made an example of, or they could even be failing. So these are certain things that we need to keep in mind in terms of plagiarism. If we want to actually write a research paper, it is important that we create our own original work. But before I end my lecture, I would like to say, especially in the context of plagiarism, when you're writing a research paper, it is not possible to write everything on your own. You are obviously going to be reading the existing literature. You're obviously going to be quoting others. Okay, that is fine. That can be included in your research paper. But at the end of the day, what you have to make sure is that you give credit to the people you have taken those ideas from. All right. So yeah, that I think will be sufficient to conclude my lecture today. If there are any questions, I'd be happy to take them. And I hope I've finished within the allotted time to me.
Yes, madam. Actually, there's a query by Professor Weber. So he's asking, can I get an intellectual property right just from the result of a research?
Yes. Right. Okay. Now, research again is is a broad classification. Research could be multiple things. You could be doing scientific research, wherein you're probably sitting in a lab and you're trying to come up with something which has a scientific development. Okay, there, if you come up with an invention, you can get a patent. Okay, of course, considering that it fulfills the requirement of novelty, utility, and inventive step. But if you do come up with an invention like that, from your research, you can get a patent over it. Secondly, maybe not scientific research, maybe simply social legal research, or maybe just, research in your discipline. Here, what you will have is that you are writing a paper, right? And the paper is essentially what? It's a literary work. And as we saw today, a literary work will be covered by copyright. Now you have to make sure that your research paper is original enough. Okay, we discussed that for something to be a copyrighted work, it has to be original, meaning that you should not have copied it from somewhere else. Now, naturally, if you're doing research, like I said, you're definitely going to be borrowing ideas from others. You're not going to be writing something completely new, obviously, right? If, let's say, you are writing something about business strategies, you will be borrowing from other people who've written on business strategies. You will be quoting those people. Make sure to put footnotes there, and then you will of course be adding your own insights. So as long as a majority portion of your research is original, you definitely are entitled to copyright over the research work.
Yes, madam. There's another question by Mr. Naveen Kumar. What is your motive or idea of design or copyright process to grab the customers?
Could you come again, please?
Yes, madam. What is your motive or idea of design or copyright process to grab the customers?
Okay. See, I don't think copyright is used to grab the attention of the consumer. Copyright is more in the sense of self-expression. Okay, copyright, you write a book, you're expressing yourself. You draw something, you take a photo, you're expressing yourself. When it comes to design, though, the purpose is completely different. Like I said, when it comes to design, it is solely with the objective of grabbing the attention of the consumers, like you said, right? So when it comes to a design, your whatever design you make on it, maybe it's a car, you design it in a way that is appealing to the eye. This is specifically done to have an advantage over the consumer, over the competition that is there, because we live in a highly competitive market, right? For every product, there are at least 10 sellers. How do you get an advantage over the other? You try to make sure your product looks more different than anybody else's, right? I hope I've answered your question, Mr. Naveen.
Yes, madam. I have a question.
Yeah.
The question is something like this. Can anyone start a business with the name of India, Bharat, Police, or Indian military? Can anyone start a business with these words?
Okay. Right. So that's a very specific question relating to trademark. There are certain conditions that you have to fulfill before you get a trademark. Okay. So, I mean, of course, since you've asked me this specific question, I'd like to answer it in specific also. If you look at Section 9 of the Trademarks Act, it has a list of grounds on which your trademark might be refused. Okay, so let's say you want to start a business with the name India, or you want to start a business with the name Indian military. Now, for you to have a trademark over that particular word, you would have to apply to the trademark registrar. Now, the registrar will look at your application and he will decide whether he wants to give you that trademark or not. In doing that, he will look at Section 9, which has a list which says that if these things are not fulfilled, you cannot give trademark. The grounds under Section 9 include distinctiveness. If your trademark is not distinctive enough, okay? If, let's say, you are selling apples under the name Apple, your trademark is not distinctive enough. Okay? In the same way, there is another ground, which is that if your trademark, what you're trying to use as a trademark, is prohibited by the Names and Emblems Act. There is an act called the Names and Emblems Act. And under that act, under Schedule 2, there is a list of things which nobody can use as a trademark or a copyright. Okay, one of those things is India. Second is the Indian Army, President, Indian national flag, the Ashoka Chakra. these are things that are prohibited from being monopolized because they have a lot to do with the integrity and security of the nation. Okay, because using the word India only, okay, only the word India would give a sense that it is something which is being sponsored by India, or something which is where the Indian government is aiding. To avoid confusion, it is prohibited from registering such a trademark. I hope I've answered your question, sir.
Thank you, madam. Thank you.
Right.
Madam, there's one more question by a student. So, can a person take a trademark on his or her own name?
Absolutely, absolutely. That is one of the best ways of actually getting a trademark. Because, like I said, if I open a store, I would rather open it in my name. Of course, there are other ways in which you can decide what you want to, register as your trademark. I think Apple did a very good job of registering the word Apple, which is like such a common word, but they're using it in terms of electronics. It's easy to remember for people, and it strikes the imagination of people. And so, I mean, the more distinct your trademark is, the better. Now, if your name is very distinct, I would definitely recommend using it as a trademark. But if your name is very common, let's say your name is Anil. Anil is a very common name. I don't know if it's common here, but it is quite common, especially where I come from. Now, if you start a business with the name Anil, what is going to happen is, if there are 10 other people with the name Anil, they might also start a shop with the name Anil, right? And there will be a conflict. Everybody will be like, no, I want to use the word Anil as my trademark. So you don't want that scenario. You want a trademark which is distinct from others, that you can use to set it apart, that consumers can remember. So if you remember the example where I showed you the different cooking oils, so you have Fortune, you have Sunflower, you have Saffola. These are all names which are, you have Fortune, Saffola, Engine. These are names that are very distinct. They're easy for the consumer to remember, and they also like strike your mind that Saffola has no meaning. First of all, Engine has meaning, but is applied to cooking oil, which is very, very different, right? So to that extent, yes, I mean, it depends on what your name is. As a legal advisor, I would first ask what your name is, and then I would probably suggest whether it's a good idea to keep your name as the trademark for a business. You're muted, ma'am. I can't hear you.
The student name is Asma, madam.
Okay, great question, Asma. Asma is actually, yeah, I think you can. It is quite unique to that extent, and yeah, I think it would be a good idea to use that name as a trademark.
Okay. Yes, madam. Thank you so much for answering all the queries. So today, as world is facing heavy competition in every sector of business, so it is very extremely important to protect our ideas. So, madam, as you have directed and shared your knowledge, which would help all of us and all of us in one or the other way. So, thank you so much.
Thank you.
And thank you so much, madam. Gratitude is not just a word, but it's a feeling. So, to show the gratitude, I request Professor Muthu Banagandi to propose vote of thanks. Sir, you please unmute yourself. Muthu sir, unmute yourself.
Yes. A very good evening to you all. It's my pleasure to do vote of thanks for this particular session. First of all, I would like to thank Dr. Veeranna C. Charantimat, MLA, Bagalkot constituency, and Chairman, BVV Sangha, Bagalkot, for the continuous support, guidance, and motivation. Thank you, sir. Next, I would like to thank Shri Gurubasava Ji Sudibhavi sir, Chairman, College Governing Council, BVV Sangha, Bagalkot, for the continuous support and guidance. Thank you, sir. Now, I would like to thank Professor Shrimati S.S. Chattar, Principal, Basweshwar Commerce College, Bagalkot, for the guidance, motivation, and continuous support. Thank you, madam. Now I would like to thank Professor Vinod Nandragi, IQSC Coordinator, Basosha Commerce College, Bagalkot. Thank you, sir. Thank you for the support. Next, I would like to thank Professor Vidya I. Vastrad, Coordinator and HOD, Department of Management Studies, Basosha Commerce College, Bagalkot, for the guidance, motivation, and support. Thank you, madam. Now I thank the organizing secretaries of this webinar, Professor Nandini N. Dodmani madam and Professor Sheetal V. Barshi. Thank you, madam. Thank you for the support. Lastly, I thank all participants for the active participation. Thank you. Thank you, one and all.
We all thank you so much, madam.
Thank you.